So I'm often asked what the process is to obtain a green card for a person's spouse if they're married to a U.S. citizen or a lawful permanent resident. Now, the first and important question to answer is, how did your spouse enter the United States? If they entered the United States unlawfully, in other words, by crossing the border without inspection, then the process for them is going to be very different than the process for a spouse who entered the United States with a visa. Now, there are exceptions to that rule, and so, for example, if you're married to a United States citizen, you're going to have the right to apply for adjustment of status. Adjustment of status is a very convenient process because it allows a person to file for their application here in the United States. Ultimately, filing for adjustment of status will allow you to obtain an employment authorization and generally a permission to travel while your application is still pending. Then there will be an interview with you and your spouse, at which point immigration will determine whether they believe you have a bona fide marriage, and then also determine whether you're otherwise eligible for an immigrant visa. If your spouse entered the country unlawfully or is abroad and has never been in the United States, then you're going to have to apply for an immigrant visa at the American Embassy. And that process is also very different and is handled through the National Visa Center. Again, it is important that if you're attempting to file for your spouse and you're either a lawful permanent resident or a United States citizen, that you obtain the advice of a competent and experienced immigration attorney. Should you have any questions regarding either of those processes, please feel free to contact my office. Thank you.